This is a new voice for a new Scotland.
indylive.radio. Hello everyone, good evening and welcome to this special edition of the TNT show. My name is John Drummond and I'm your host for the next 60 minutes. Thank you very much for joining us this evening. We have a very, very special guest with us and I know you're going to enjoy hearing from him. But first, a few words about TNT. TNT stands for The Nation Talks. So in many respects, if not all respects, this is your show. We love your questions. We love your comments, good or bad, whatever you feel is important to us. We want to improve and get better, and we can't do that without your feedback. So we appreciate your thoughts. Some of you may have sent questions in advance. Certainly deal with those. But do remember, during the course of the show, you can contact us live. So feel free, give us your questions. Now, to our special guest this evening. We have with us tonight Martin Keatings. Now, some of you may know, and many of you I'm sure will appreciate, Martin is convener of Forward as One. You may recall that Forward as One was formed to challenge the UK government's refusal to agree a so-called Section 30 order, which would enable the Scottish Government to run another independence referendum. Now, Martin's a full-time carer and suspended his engineering studies to care for his mother. So he's got a lot on his plate because he's going through quite a sophisticated and complicated court case, which takes up a lot of time and energy, and hopefully he'll tell us a little bit about that tonight. Okay, Martin, over to you. How are you coping with COVID-19?
Well, like you said in your introduction there, I'm actually a carer, so isolation in the house is pretty much dead certain. You know, it's pretty much part of the job description. So, and of course, we entered lockdown about 4 to 5 weeks before the rest of the population as well. So, but when you spend so much time in the house anyway, you know, it doesn't have as great an impact as it does somebody that's out working every day and suddenly finds himself boxed in. So, coping with it quite well.
Good.
What about you?
Me, I'm gracious. I'm all over the place. I mean, I get out and about. I do some shopping and some exercising. Not as much as I should, I'll grant you. But I reckon I put on about a stone, so that has to come off sometimes. But I suspect I'm not alone. See, I'm really excited to learn more about Forward as One. Can you take us through it? What Forward as One is, how it was formed? You're the convener. What's your role, and how does it work? And then maybe we can talk a little bit about the court case.
Well, Forward as One was actually built on the back of what was Yes International. I was head of Yes International from 2011 right through to the first referendum, at which point I kind of took a hiatus for a number of months, and then Forward as One was formed thereafter, specifically organising marches and rallies in Dunfermline for 4 years running. We have obviously our own written constitution, and in that it says that we will partake in any activity which pushes forward the goal of independence for Scotland, and that has led us to a point where a promise was made pre-December 2019, where if a Section 30 order was stopped for a second time and then refused by the UK government, it would result, if the people decided, and as representing them in an action against the UK government on that subject. And I'm pleased to say that 1,900 people did back that decision, and we now find ourselves pushing forward with that action.
So you've got 1,900 supporters, financial supporters?
Yeah, 1,900 financial backers. The number of actual people that support the action obviously can't be counted. So, but that's 1,900 individual financial backers to the case. So.
Excellent. And are you in contact with them? Do you have a regular, do you have a web page and stuff? I mean, how do people get to know what you're doing and what's happening?
Well, the original we're in the process of actually going to establish a website for the purpose of disseminating information as we go. Primary contact in the first stages, which began in December when we commissioned the advice of Aidan O'Neill's QC, that was primarily done on social media, and then we obviously launched the first fundraiser at that point through Crowd Justice. Now, the 1,900 backers then backed that action, and obviously that platform has the facility for us to communicate. So as we've progressed through the months to this point, we've been emailing those that have backed the case and obviously publishing that publicly as well. So, but eventually we will have a site specifically dedicated to the case, so updates can be put on there for everybody to see.
Good. I mean, it sounds like a mammoth undertaking. I mean, here you are, as it were, a bunch of private individuals, I mean, even allowing for all your backers, and you're taking on governments? Are you challenging the UK government, and is the Scottish government aligned with you, or how does it all work? I mean,
the thing is, though, the Scottish government, I'll say from the offset, isn't aligned with us. They're not working with us, okay? And that was specifically by design. As you'll recall, the First Minister and indeed the Scottish Government have asserted on multiple occasions that they wouldn't proceed with regards to a Section 30, or, they wouldn't proceed without a Section 30. And, that was right and that was correct from the position of government with regards to what we know at the moment, which unfortunately is extremely ambiguous in terms of the actual status that the Scottish Government holds with relation to that. So how we best sought to approach it was not to consort with the Scottish Government, so to speak, but to proceed with the action against the UK Government on the question and invite the Scottish Government in to make their own representation. So at every stage, we've kept them informed that there is no alignment between the positions. We've allowed them to be free because that gives them the opportunity to turn around and say, well, listen, this action is happening. We actually have nothing to do with the action. We're being pulled in. But as the government, we have a duty in matters as substantive of this with regards to constitution to represent the Scottish people and the Scottish Parliament and subjects that affect it. So we did that deliberately because we wanted it to show clearly this is an action of the people, for the people, not an action in consort with any government. As to the UK government, then the position was put to them very clearly with regards to the opinion that we sought from Aidan O'Neill QC. They were asked to respond to that opinion, which obviously they came back, and it was a very short response. We do not believe it's within the legislative competence of the Scottish Parliament to legislate for a second referendum without the consent of Westminster. And that then created the circumstances that there was a clear disparity there between the positions, and consequently that has now resulted in it going to court to ask them to render an opinion on that question. Is it or is it not within the powers of the Scottish Parliament to legislate for a second referendum without a Section 30 order?
So could I describe the Scottish Government's role in this as an interested observer? They're officially designated as a defender in the action. So they were summoned very much like the UK government was. But ultimately, their position in the case is one of being an interested, or should I say, a third party with an interest in the case. So, that's very much how we approached it with them. So, and rightly so. Okay. So, well, you described them as not a defendant. I'm trying to remember the word you used, but
A defender.
A defender. Yes. What does that mean? What? I mean, that sounds like a legal term, obviously, but what does it mean in this context?
Well, it is. In any case in Scotland, normally you would, in England, they have different terminology for it, but in Scottish cases, typically you have two parties. You have the pursuer, who is the person that's taking action against somebody, and you have the defender, which is the person defending against the action. Right. Because there's really these only two options. Whenever a pursuer commences action, in the case of the Scottish Government, the only way to effectively list them is as a defender alongside the UK Government. So in this case, the defenders are the Advocate General, which is the UK Government's highest legal counsel here in Scotland, the Lord Advocate, who is the Scottish Government's legal counsel, and the Scottish ministers themselves. So they would be classified as defenders 1, 2, and 3. Obviously, with regards to the two, with regards to the Scottish Government's legal counsel and the Scottish Government, it's not so much an acrimonious, we're taking legal action against them, it's inviting them in as a third party, but they do have to be listed in those terms.
It's a slightly odd term, but I guess that's the law for you. And I guess you've learned a lot about the law in this, while you've been doing this.
Well, without a doubt, I've learned a lot, but what I would stress is that what I have learned is infinitesimal comparative to what there is to know. I mean, legal professionals at their height, they've been practicing for 30 years, still don't know it. And that's primarily as a function not just of the mechanisms that they use, but also the fact that the law changes literally daily with new precedents being set and new primary legislation being created and old legislation being modified, and it can be a real quagmire. So yes, I would say I have experience of the court system, but I would not say by any means that I am an expert in it. I simply would never try to claim that, for no other reason than I have enormous respect for the people that are in that field. You have to have a real dedication, particularly with the likes of our legal counsel, Elaine Motion, who is our instructing solicitor, and Aidan O'Neill, who is our QC, the advocate. They are top of their game, and to get to those sorts of heights, you just have to have one of those minds. You just have to have the ability to absorb so much and the ability to analyze extremely deeply, and you have to be able to, at the same time as well, articulate what you're saying. I have enormous respect for our legal team. They are brilliant. There's no way to put it, no other way to put it.
Was it Aidan who was involved in the court case that Joanna Cherry was involved in over the proroguing of Parliament?
Yes, both Elaine, in fact, Elaine and Aidan were both involved. Prorogation case, yes.
Interesting. I appreciate your point about the terminology. I've just come across a classic. It says here, now a decision is being made on whether forward as one should delay the case. And apparently the Scottish legal term for delaying a case, and it sounds terribly painful, is assist. S-I-S-T. So in this sense, assist merely means we're asking for a hiatus or a delay of some kind.
The English courts would refer to it as a continuance.
A continuance. Okay, got it.
It's effectively a temporary pause for a fixed amount of time, and it's usually in Scotland up to a maximum of 3 months, which in this case is what was applied for by the other parties to the case. Obviously, we opposed that motion. Court sided with us, and the primary reason for that was because after defences are lodged, there's an 8-week adjustment period. So it's 8 weeks. No big deal. And of course, we put it firmly on the table that based on the current circumstances, we're not going to act unreasonably. If they have just cause for us extending that adjustment period, then we are willing to listen to reasonable requests with regards to that. Yeah. So the court agreed with us, and as a result of that, the deadline for lodging skeletal defences was extended by 7 days, which brought us to today. And those defences have obviously now been lodged. So
now, what in heaven's name is a skeletal defence? I mean, you're obviously au fait with all of this, but a lot of the people tuning in were just, I've never heard of a skeletal defence. It sounds like a sort of preliminary or a draft of some kind.
That's effectively what it is, yeah. In the court of session, what you get is you go through the summons stage, and then defences are lodged. So when you summons, you effectively lay out your arguments on why you are initiating the case. There's then statutory period for the opposition parties, the defenders, to then lodge their defences to the case that you've put forward.
Yeah.
At that point, typically, there's an 8-week, what's called an adjustment period, and that's where all the parties can refine their arguments, make tweaks and changes. After seeing the opposing arguments, they can add bits in, take bits away, etc., etc. And that typically lasts for about 8 weeks. A skeletal defence is effectively just enough to lodge your defence. And then what you would do, so it's basically a basic outline of how you expect to argue and what points you expect to argue in the coming case. And then you would then use the 8-week adjustment period after it to expand on that and refine. And obviously the defence would become bigger and bigger and bigger and bigger.
Oh, gracious. So you're still, it sounds like to me, you're still in the foothills of this case.
Oh yeah, we've just taken the first step at this point. we've got the 8-week adjustment period, and there'll be wrangling back and forward. And I have no doubt that there will be probably a couple of motions put in over the next number of months that we will have, the parties will argue about. And I have no doubt that there's going to be a lot of adjustments in terms of our arguments and their arguments on both sides of the table. So procedural things as well.
Let's look at a couple of, if we can. I mean, it might be early days and you might not want to go there, but what would the end point be? I mean, am I right in thinking that the end point will either be that you win the case and therefore a referendum can go ahead, i.e. the Scottish Government can go ahead regardless of a Section 30, or you lose the case, in that case we're back to square one and it needs a Section 30. Is that a reasonable summing up?
It's probably a bit more complicated than that. Obviously, you have to remember that there's the ability to appeal any decision as well. So it may possibly go to an appeal stage. But what you have to remember is that what we're arguing is not against Section 30. It's not against anything. What we're arguing is that the Scottish Government has the competency now under the law to be able to legislate for a second referendum itself. When that is ultimately answered, it will be up to the Scottish Government how they proceed. If the court rules in our favour, then the Scottish Government will know that it can legislate for that referendum without the consent of Westminster. They may very well choose to say to Westminster, give us a Section 30 or we'll do it ourselves. They may very well decide just to go ahead and use it. But it does bear mentioning, especially in light of the continuity bill, that there is a possibility that the UK government might try to pull a fast one by changing the law, which is actually one of the reasons we decided to go ahead with the case now rather than wait until after a bill was put on the floor of the Scottish Parliament for a referendum. So,
what does that mean, that the UK government could go ahead with its what you said, a continuity bill? Sure.
Well, no. If you remember the Scottish Parliament, when the Brexit referendum happened, the Scottish Parliament put forward a bill called the Continuity Bill. Right. And effectively what the purpose of that bill was to effectively enshrine certain laws that we derive the benefit from at the moment as a result of being in the European Union. And to ensure that powers coming back from Europe were properly retained by the Scottish Parliament. Yeah. Now, that bill was put before the Scottish Parliament. The presiding officer immediately queried whether it was within the remit of the Scottish Parliament. It was then declared as what was called a devolution issue. At that point, you had a fight ensued between the UK government and the Scottish government in the court, whether the bill was competent or, because it could have gone either way. The court might have said it was reserved to Westminster or it was devolved to Scotland. Now, during the action on that bill in the court, the UK government pulled a fast one. And what they did was effectively modified reserved legislation at Westminster to undermine the continuity bill, effectively making what was competent for the Scottish Parliament to do suddenly incompetent. And of course, the moment they did that, certain parts of that bill effectively became incompetent. So that was a bit of a fast one. Now, and I have to get this right, so you'll have to bear with me one more. The UK government, and this is something that I've asserted for a long time, operates on a modus operandi of ambiguity. In other words, if we keep everything ambiguous, then the electorate will never know what is or what isn't. Section 30 is a perfect example of that. The truth is, there is no legal authority. There has never been a precedent set with regard to Section 30, whether the Scottish Parliament could legislate for a second referendum without the permission of Westminster, because they didn't go down that track in 2014, actually got the permission. So because there's no precedent on it, there's this cloud of ambiguity that hangs over the entire issue surrounding a Section 30 order. And that serves the UK government's agenda, because as long as that ambiguity exists, they can turn around and say that any referendum that the Scottish Parliament tries to hold without their permission is a wildcat referendum. It's illegitimate, it's unlawful, etc., etc., etc. So the second the Scottish Parliament was to put a bill before the Scottish Parliament calling for a referendum without the permission of Westminster, exactly the same thing would happen as happened with the Continuity Bill. It would be declared as a devolution issue. Westminster would claim that it is not within the competency of the Scottish Parliament for them to legislate for a second referendum. It would end up in the court, and the court case that would be fought would pretty much be the same court case we are bringing now. So what we're doing is effectively preempting that by answering the question now. So it's an issue.
Correct me if I'm wrong. You still have the same problem though, because at any time it sounds to me the UK government can arbitrarily decide that this incident is going to be a devolved matter and rule it incompetent in some way.
They can do. However, there's a number of options. Obviously, I'm not going to go into detail with this because it comes down to what we may or may not do with the case later on. All I will say with respect to that is that there are other options and there are other things that we have planned with respect. I'm not going to say anything at that point, purely on the basis that I need to seek clarification from legal counsel, but also I'm not sure how that would affect track later on. But it is something we have considered. That's all I will say.
Good. We've had a question from Robert, and he says, "Thank you, Martin, for taking this on." But he says, "I truly believe our independence and sovereignty should be taken to the ICG, which I assume means International Court of Justice."
Yes.
What's your reply to that?
What I would say to that is that you will typically find with international courts, whether it be the European Court on Human Rights, the ICJ, etc., they will not hear a case unless you've exhausted the options within your internal legal system. Yeah. So you have to go, in Scotland it would be Outer House of Court of Session, Inner House of Court of Session, then apply to send it to the Supreme Court of the UK, who may not decide to hear it, but you would have to exhaust each stage within the domestic legal system before you could then on. The only real exception to that is where there is very little chance that it would be heard here in the UK, or where there is a substantive enough conflict of interest with respect to the National Court hearing it before it went to that, or if it's a matter of severe urgency, typically to do with where somebody's life is on the line, for instance. But typically, you have to exhaust your domestic options first before you can go that track. So, yeah.
We've had another question, again from YouTube, and it's from Hashbury, asking, could the fact that a Section 30 has not yet been requested influence the judgment that might be handed down?
Section 30 has been requested twice. It was first requested under Prime Minister May, who didn't bother actually responding to it. She went on TV the next day and said, now is not the time. The second time that it was formally requested was to Prime Minister Boris Johnson. And that was it November or December? And in fact, this case is directly related to the fact that Boris Johnson wrote back to Nicola Sturgeon and said, no, you're not getting one. So this case is actually in the back of that. So Section 30 has already been requested, and that's actually one of the primary reasons that we're proceeding with this case.
It's interesting because Theresa May's response sounds very conventional by saying, not now. That's ambiguous. That plays into that playbook of never committing, making it possible for your remarks to be construed one way or the other, deliberately confusing, in fact. Whereas if somebody says no, like Boris Johnson did, that's not ambiguous. That's pretty straightforward, pretty clear cut.
It is. But that's one thing about Boris is he's always been one of these politicians who likes to play on the baser instincts of humanity, typically leaning towards fear or towards he likes to push this personage of the iron fist. So an ambiguous answer to something like that would not really be fit with his persona, and certainly wouldn't play well to his base. So I think that's where the rejection was a start. No. in terms of what he was, of what he was actually doing. Miss May, however, she, despite her being a Conservative, she's more of a moderate. She tends to be more diplomatic in the way she phrases things. Although what I would say is that her response was actually quite disrespectful. She didn't really respond. I'm sure of this, she didn't respond in writing to Nicola Sturgeon's request, which was put in writing to her. Her response was effectively on TV the next day saying now is not the time. It is not the way to respond to an official letter from what is effectively a head of a nation, namely the First Minister. So,
okay. Got another question coming up, Martin. Questions are coming in thick and fast. You've clearly struck a chord here with the folks who've tuned in, which is great, fantastic. But just let me, because we're almost at the halfway stage, let me remind everyone, this is your chance to ask Martin questions. It's one of these very special times that you actually get a chance over a longish period to talk to somebody who is hugely active and expert in the field. Doesn't happen very often, and it certainly wouldn't happen in a conventional broadcast that you would get all of this time to put your questions and for Martin to have the time to answer them. But do remember, you can contact us on YouTube, Facebook rather. Also, you can text your questions, or you can send them to my email, john@cleach.com. All of these avenues are available to you. So quickly, let's move on. A question on Facebook from Stephen Kelly. Is there any prospect the SNP, and I know you can't talk about the SNP, but broadly theoretical terms perhaps, is there any prospect of suspending the Act of Union?
Okay, I'll preface this by saying this is my personal opinion, but I will back it up with the reason why. I would say a stern no. And the reason I would say a stern no is because of a multitude of factors. The primary factor is international recognition. No country that has ever become independent without international recognition has effectively survived economically. That is true with unilateral declarations of independence, particularly countries like Zimbabwe, etc. You tend to find that without international recognition, it becomes very, very difficult to access the economic levers and the normal facilities with regards to economics worldwide that a country needs, particularly in its early days of establishing itself as an independent nation. International recognition comes from the only time that a country has really survived something like a UDI, etc., is being a country that has been in the throes of war, where the country is split as a direct result of an internal conflict. The only real way to get proper international recognition with a peaceful process has been to first go through every single step that you possibly can to do it within the framework of the system that you're stuck within. And only then do you take the step of moving away or diverging outside of the system. At that point, because you've been through every step, international community will, of course, recognise that you tried everything first before initiating UDI. The reason that I say that the SNP won't just dissolve the union or UDI is simple. We won't need it. And the reason we won't need it is because as we go through each step on the journey along to independence, we're going to be using democratic processes. And it will certainly come to a point, particularly in light of the fact that we've now pretty much got 27 new supporters with the UK pulling itself out of the European Union, that I don't think we will get to the point where we require anything but a democratic process to become an independent nation. Certainly, particularly, and I know I don't like to politicise it, but if anything, this COVID-19 situation has shown that the Scottish Government, the Scottish Parliament is best placed to serve the Scottish people. And I think that will do a lot in terms of convincing people to become, to move towards independence. So will they suspend the Act of Union? No, I don't think they'll ever get to that. But even if it did, without having a solid foundation internationally in terms of recognition, it would be a serious, serious risk, and one that any responsible leader probably wouldn't take. The consequences for everybody in Scotland would be disastrous, has been for countries that have found that, tried it in the past. So.
Yeah, and there was another question on YouTube, but I think you may have answered it. It's from Ashbury again. Was that an official request rather than just a letter to Boris that you were referring to earlier?
No, that was classified. That was an official request to begin negotiations on a Section 30. She responded and said no, and it's actually quite condescending in that response. I actually think we have a copy of it on Twitter, on the case page. I'll tweet that out after the show if I can the letters. So,
well, here's a question that was almost bound to come along, and it's from Lenny Harry in YouTube. What about secession? Why should Scotland play their game?
Well, secession is ultimately a terminology for dissolution of the Union in our case. And secession can be done a multitude of different ways. Democratic options are always the best options, and for everybody concerned, at least not the international community can actually assist in enforcement of that. For instance, what was mentioned earlier on the international courts, for instance.
Yeah.
It's not a case of playing their game. Let me spell that out clearly. This is not this case, and indeed everything that the Scottish Government has done is not about playing Westminster's game. What it's about is showing the rest of the world that we have tried every single thing within the system we are being subjected to. That's the important thing. Only once we exhaust each of those does it then become time to operate outside of that system. So it's nothing to do with the UK government. It's about showing the rest of the world we're responsible enough, we're adult enough to try everything in our power within the system first. And then when you get to that block where you've tried everything, it no longer becomes a question of did you try everything? It becomes a question of the system which you are subjected to has failed you.
Yeah.
And then the scenario takes on a whole different meaning. So, at that point, other options, more radical options can be considered. But as I say, I don't think we will need to get to that point.
Interesting. Where, in your view, does sovereignty rest in Scotland?
Oh, there's no question with people. There is no question on that. My opinion, and it's not just my opinion, it's something which is enshrined in Scottish law, because it's been averred by both the Scottish Parliament and the Westminster Parliament, the right to determine our own future under the claim of right. It's the people in Scotland that are sovereign. So there's no question in my mind that is a matter for the people of Scotland and nobody else. I say that unequivocally. It just is.
But isn't that a conflict with the Westminster system, which maintains that sovereignty is vested in the Crown and Parliament, not in the people?
Yeah, well, it does conflict, yes. Indeed, that's one of the primary issues in this case. Sovereignty is effectively a measure of where power resides and who has the right to exercise power. In England, that power resides with Parliament. In terms of sovereignty here in Scotland, that resides with the people. And that has been agreed by both the Scottish and the UK Parliament. In fact, I think, 2 years ago, the UK Parliament voted on it. Of course, all the Tories were off watching the cricket during that debate, or the football, one of the two, and comments were there and made when they returned. But nonetheless, that claim of right has been averred, and not just in recent years, continuously since the campaign for the first Scottish Assembly. So, way back when. So, sovereignty, but there is this conflict, and indeed that is one of the major issues with regards to sovereignty. And the position we argue from is that if sovereignty is where power lies, and the exercise of sovereignty is the exercise of power, then surely by seeking permission from somebody else to exercise power is completely antithetical to the nature of sovereignty. You can't argue that if you're having to ask permission from somebody to exercise sovereignty, that it is sovereignty, because it's not. And that's actually the position we argue from. The people of Scotland are sovereignty, therefore the decision on whether or not we call a referendum on what our constitutional future is going to be is a matter for the people of Scotland, not just the decision at the, in that referendum, but also whether or not to call that referendum. And ultimately, that's what this argument is all about, for this case. So,
but surely, if you accept that premise, and I suspect I would agree with it, which is that the people of Scotland are sovereign, then it would apply not just to the Section 30, it would apply to pretty much everything.
I agree.
In other words, you can understand why people who also take that view would argue that's a case for UDI. Because clearly, if you're sovereign, you have the right to do whatever you want.
Yes, I would agree with that. Yes. However, it's not a case of exercising the power of UDI. That straight away. We could do it. Yes, by all means we could do it. But we have to remember that we live on a planet with 196 other countries. Yeah. And in order for us to be able to survive and stand on our own 2 feet, whether we like to admit it or not, because we're a proud people, we do require the recognition of the international community.
Okay, that's great, Martin. You made that point before. It's a very good point. We've got a lot of questions coming in here, masses of questions. Here we go again. Sandra on Twitter is asking if I could ask you what's happening with the legal action, because she says there was something happening in court today. Are you in a position to say anything about that?
I can, yes. The case today, as you all know, as I explained earlier on, it was the lodging of skeletal defences today, so effectively basic defences. Now, it had been my intent to come onto this show and fully discuss what those defences lodged were. However, having read the defences, and at this early stage we have to seek consent from the other parties to be able to release their defences. Having actually read them, I can tell you I'm not surprised that they denied us the right to release those defences to you. All I will say is how exactly do you argue that a national government and a national parliament has no more power than a local council to a population of 5.4 million people without, shall we say, getting them slightly annoyed? So at this early stage at the moment, I can't go into full details. What I can say is that the first hurdle we're probably going to face at this stage is that the UK government are going to challenge our right to even bring the case. That looks like it's going to be the first hurdle, purely on the basis that we are not members of Parliament. However, what I will say, without referencing this case, is that the 2 other cases that have dealt with constitutional matters of late, but in particular the Joanna Cherry case, the courts didn't react too well about being told to effectively keep their nose out when it came to matters of constitutional significance. So on the basis that this is backed by 1,900 financial backers thus far, there is definitely clear legal standing there for us to bring the case. All we're asking the court to do is exercise its primary function by giving us an opinion on law, which is the whole reason it exists in the first place, for the purposes of ensuring that we don't have constitutional paralysis later on. So, there's a very strong case of understanding, and I'm sure, I'm almost 100% sure that the court will agree with our assessment on that, just like they did in the Cherry case, that it is a material matter that needs to be the subject of a solid legal discussion in court. So, yeah. This
is despite the fact that Tony Blair was unable to draw a distinction between the Scottish Parliament and a local council in England at one time, if I recall.
It wouldn't surprise me. After all, we're talking about a government that their entire motivation for creating the Scottish Parliament in the first place was to kill nationalism stone dead. All I will say to that is that really worked, didn't it? So, wouldn't surprise me. I've heard several Conservative members as well, including one Tory frontbencher under May's government, I think it was either Cameron's or May's, saying that she wouldn't give powers to the Scottish Parliament that she wouldn't give to a local council in England.
Yeah.
That way of thinking is endemic within the Westminster Parliament.
Yeah.
As we struggle with daily, but ultimately it will be to their cost politically. If they want to run around shooting themselves in the foot, then, fair enough. That's up to them.
Interesting. Oh, we've had an interesting question here. You'll like this. or maybe not, as the case may be. Robert Appleton has submitted a question on Facebook, and he says, what state would Scotland be in at this moment if we were independent, when even Italy had to turn to Russia to help them out? Where would we be now?
In a damn sight better, condition than we're in just now. Let me put it this way. It's estimated that on day one after independence we'd be approximately 0.6 to 0.9% better off in terms of our GDP. That's without me including the return of funds that we would gain as a result of not having Westminster buying things on our behalf. So, certainly we would have been in a much better position. There would have also been a better ability, particularly with regards to COVID-19, to be able to respond to this problem a lot quicker. What I mean by that is a lot of the hang-ups and the delays in being able to respond, for instance, with lockdown and things like that happened in Scotland, was a direct result of waiting for primary legislation to go through at Westminster. Legislation goes through at Westminster, modifications to legislation goes through at Westminster. At that point, the Scottish Parliament was then able to put its legislation through. Because of that delay, ultimately it delayed the response as well. What we'll also see as well is that, for instance, this Nike conference and other material matters, there was information that didn't make its way to the Scottish Government in time. If Scotland had had full fiscal autonomy and had the ability, full fiscal autonomy, which we were promised in 2014, I will add, then we would have been in a much better place, not just economically, but also in terms of having the ability and the full levers of every single aspect of our own country to be able to respond to the issues that we're facing. It's just a fact. A lot of the decisions that we are having to make right now are reactive based on issues that are caused further up the line at Westminster. And we certainly wouldn't have had issues where Westminster invited us in to be part of joint purchasing agreements.
Yeah.
And then stealing our PPE. We wouldn't have had those issues. So, yeah, it just is. It's a fact of that. It's a fact of that. But I don't want to really politicise the COVID-19 crisis.
Got it. Let me ask you a different question then. Well, it's related. Christopher James dropped us an email, is asking, when can we expect a decision on the court case, and what will the impact of that decision be if it goes in your favour? Well,
that is a complicated one. So I'll try to give a brief answer, but it is a complicated one. Can you just repeat the first part of that question?
Yeah, so when can we expect a decision on the court case, and what will be the impact if the decision goes in your favour?
I would expect, and again, this is just a rough estimate, we have an 8-week adjustment period. There's a possibility that it could be extended a little bit, probably by a number of weeks. At that point, we would be expecting the case to call probably within 4 weeks. Now, I'm prefacing this by saying this is provisional, purely on the basis that nothing is normal in terms of timetables, and it ultimately comes down to resources. So I would expect the decision to be likely published by the court 4 months from now. That is my rough estimate, but that can be subject to change, obviously. It might be quicker, it might be slightly later, but ultimately it's dependent on a lot of things. In terms of what happens after that, I would think that either the UK government will try to appeal it. If they don't, we have the situation where it really ends up in the First Minister's hands. If she has a paper in one hand that says that she has the power to call a referendum without a Section 30 order, then I'm pretty sure most people, particularly on our side, would expect her to use that. Whether she's using that to legislate for a second referendum, or whether she uses it as leverage to gain a Section 30 order from the UK government by saying, give us a Section 30 or we'll do it ourselves.
Okay. Here's a question that's come in. We're almost running out of time. Well, we are running out of time, but we might just have... Thank you for your forbearance, really. This is a question from Mike Fennick on Facebook, and he's concerned about dirty tricks. He says, what if Boris says yes to a Section 30? However unlikely that might be at the present, but with conditions. and you know we've been down this route before with the first failed devolution referendum, perhaps setting a threshold of 60%, or that we must agree to no further referendum for a generation, and that Boris might use when he says no. There is a sense of what happens if the referendum is agreed to, but is laden with conditions that make it practically impossible to secure a positive result.
I could tell you straight away that the threshold of 60% would probably be a red line for the Scottish Government. That's how they duped us out of getting an assembly back in 1979. But that was called the 40% rule, which was actually put forward by a Labour MP, if I recall. But obviously that was 40% of the entire registered electorate, which is effectively the same as 60% of those. So pretty much the same thing. I think that one would be a red line, particularly considering the precedent has been set, 2014 referendum, with regards to effectively the entire franchise. It is my belief that if Boris was to say yes to Section 30 and then try to put a stack of conditions on, that would likely end up with the Scottish Government in court with against the UK Government putting red lines, and then it would be a determination of the court from that point. I would probably say there's a good chance that they would side with the Scottish Government on the basis that all this was settled back in 2014. You can't just change the rules later on because you suddenly realise you possibly lose, you know, especially considering the Brexit referendum as well. So,
yeah. Okay, here's another question. Stephen Kelly asks, surely you can bring an end to the union simply by withdrawing MPs from Westminster?
This is actually something that originally would have been the case. What I mean by that is indeed Margaret Thatcher, the Toryist of all Tories, actually stated just that.
Yeah.
All they need to do is send a majority of MPs to Westminster that are of a pro-independence disposition, and that would be the end of it. But since devolution has occurred, since the Scotland Act came into effect, that's pretty much kiboshed that issue. The only result that would come from withdrawing MPs that we would have, was it, how many elected MPs do the SNP have at the moment?
Kind of 50 odds, I guess. I mean, it's all but a handful, really.
All that would happen in that case is that we would end up with those MPs not voting, and the UK government would shove through a load of legislation to stick it to us. None of our MPs there to represent us and scream about it. So devolution in the Scotland Act effectively kiboshed that as an option.
Yeah. I guess it would also be the problem with constituents complaining that they weren't being properly served by their MP.
Exactly, yeah.
That'd be a reasonable point to make. Another question from, looks like Irene Dobson. Could you just clarify, when you're talking about a court case, it's a Scottish court, but not England's Supreme Court, she asks.
Right, well, it wouldn't matter anyway. The court we're arguing in is the Court of Session, so that's Scotland's Supreme Court. What I would say, however, is that in the event that it were to end up in the Supreme Court of the United Kingdom, it would be under Scots law, not English law, because it had been previously fought in a Scottish court. So you would find that probably a majority of the judges in the Supreme Court would actually be Scottish judges, not English judges. So that's typically how it works. So.
And are there enough Scottish judges on the Supreme Court to make that meaningful?
Oh, yeah. I think it's already been done twice, if I remember correctly.
Right.
You've got to remember, it's normally not the entire, for a case like this, it's normally not the entire court in session. It'll maybe be 3 or 5 judges. So it probably wouldn't be the entirety of the court in session. So,
and it would only end up there if the UK government challenged assuming you got, as it were, a positive result coming up, it would only end up in the Supreme Court, I take it, if the UK government challenged that ruling.
Yeah. Thing is, though, typically what you would find is that it would probably stop at the Court of Session, because you've got to remember the Court of Session here in Scotland has its own appeals court. So it would probably stop at that point. I would suspect at that point, because Scotland has a unique and distinct legal system from the UK government, from the rest of the UK, there's the option for the Scottish courts to refer directly to Europe, therefore bypassing the Supreme Court. So I would say it's probably unlikely that it would end up in London.
Really?
Yeah, I would. It was probably unlikely that that's where it would end up. It's more likely that it would end up at the appeal being conducted here in Scotland, and at that point skipping over it. So we'll just have to wait and see. But it might very well transpire, as it has been in the other cases, the UK government doesn't appeal at all. For instance, the prorogation and the Joanna Cherry case and the Whiteman case, they didn't go to that level. There are different mechanisms. It's too complicated to say at this point, but there's a possibility it might not even end up in the UK Supreme Court. So.
Yeah. Oh, that's interesting. So the whole matter might be settled in Scotland.
Oh yeah, without a doubt. Without a doubt, it could be done. Yeah. It really depends what happens at what time and what the circumstances are. It's a very complex question to answer that one, and we'd have to see what would happen. But certainly, if it did get to that point, I would keep everybody up to date on what was happening. So
yeah. And do you feel you've got? I mean, you've been very complimentary about your legal team. I mean, you have real confidence in producing. Yeah. Okay.
In Elaine Motion, she is the chair of one of the biggest law firms in Scotland, which is extremely difficult for a woman, to do. I mean, we've really only Lady Dorian, for instance, who is now the second highest judge in Scotland. The transition to women on the bench has been a gradual one, and it's still a long ways to go. There is bounds, but she's a rock star as far as I'm concerned. She's very talented, very good at her job, and sharp as a tack. And as for Aidan O'Neill, well, yeah, he's basically a courtroom assassin. he's a courtroom ninja. If you've ever seen that case, he just, he's got a way of pulling, and the way he looks at the law as well. When you actually read his opinions, he has this way of seeing things just, different from.
Yeah. I was glancing through his 40-odd page summary of his take on the Constitution. Yes. Absolutely fascinating. Absolutely, I commend it to everyone if you're happy to sit down and wade through 47 odd pages. Thanks very much, Martin. Our time's almost up, but you depend, in order to pursue all of this great work, on crowdfunding. Do you plan to have another crowdfunder soon?
There will be, yes. However, there's a few technical details we need to sort out before we announce the next crowdfunder. But this type of case, one of the issues in any court action is the expense. So we will be doing another fundraiser, that is a definite. But we just need to nail down the technical details, because I want to make sure that I have all the information for everybody before we go ahead and launch that. But once I do, I'll keep everybody up to date. So
good. And so they'll be able to find all the information there.
Of course, yeah. We'll start by emailing the 1900 backers that have already backed the case. And of course, if the people subscribe to the Twitter feed as well, each time I put up an update, I also fire it on the Twitter as well, so we can keep up to date there.
Martin, this has been excellent. Judging by the questions, people agree with me. You've been a great guest. You've told us so much that I suspect most people were completely unaware of, and I suspect they'll want to know more from you. Would you be happy to come back at some stage?
Of course, yes. Problem whatsoever. It's actually great. Some of the questions have been absolutely brilliant. I'm really chuffed with them. So, I mean, that's one of the aims here. I don't just want to do we don't just want to proceed with this case. I also want to try and give people an understanding of exactly how complex the legal system is. Excellent. Especially in light of the fact that Boris Johnson, etc., are trying to paint the judiciary as enemies of the people, which is just not the case. These people protect our rights; they're a vital part of our society.
Good message to end with. Yeah. Thanks very much, Martin, and I appreciate you taking the time. It's not easy. You've got a busy schedule there. Well, folks, I hope you've enjoyed the TNT show tonight. We've got a formidable list of guests lined up for future shows. Join us next Tuesday at 7 p.m. for another, I guarantee you, exciting show. In the meantime, look out for my column and the Constitution column in the Sunday National. And more importantly, support Indy Live and Indy Live Radio. New Voices for a New Scotland. You'll find the details on the site. Go straight there right now and give them some hard cash so they can keep doing great interviews like this. Thanks again, Martin, and a very good night to you all.
This is a new voice for a new Scotland.
indylive.radio.